me bring in my guest to discuss. Joining me now in studio, National Trial Attorney Michael Jaafar. Michael, always great to see you, but to have you here in person for really this big news. But let's start first with that opening statement. Very clear for the jury. Finding that he murdered people, that's not enough for the death penalty. These are the aggravating factors we're going after. These are the ones you can find are true. We're asking you to do that, not on evidence, but you're going to hear from victims. You take the evidence into account. Very clear plan, I think, spoon-fed to the jury.
I think that the jury right now has a very difficult job. I think that the prosecutor is going to spoon-feed them, like you said. These aggravating factors, I've read them, I've listened to the prosecutor. I just don't see that murder is not enough to present aggravating factors to substantiate a death penalty. I'm really interested in what we're going to see, and I'm really flabbergasted that there's not going to be a defense on the other side. There isn't going to be anybody to rebuff that and say, well, no, that's not correct, and there's some mitigating factors. I'm kind of baffled, kind of, you know. I wish I was next to, what's his name, Chad Daybell. You're not Gandhi, right? No one's you're not gonna punish yourself and make society suffer by punishing yourself. Nobody cares, you're a convicted killer. So I really wanna see whether or not the death penalty is imposed here. I don't believe it should be imposed. I don't believe that the aggravating factors meet Idaho law, but we'll see what happens.
And I think they do, given the way that especially the children were killed. I think the aggravating factors are met, but that's part of the job of the jury to have to make that decision. Now, John Pryor, I suspect, probably said to Chad Daybell, no, we present mitigation, and Chad waived that right. So now let's go in, because John Pryor is going to make his remarks to the jury, his opening. Let's hear what he has to say. Let's bring in Michael Jaafar, still with me. Michael, let's talk about this aggravated manslaughter charge in New Jersey. It is when someone recklessly causes death while showing an extreme indifference to human life.
I agree that that was bad. There was recklessness here. I like the jury. I like what they did. This is when the jury system really works. I think it was clearly reckless. And he should count himself lucky.
Yes.
Lucky that he didn't get convicted of the big charge. And I'll tell you why. Whenever there's a death of a child at the hands of a parent, I've seen juries over-convict. In this case, they didn't. They convicted the proper charge.
And well, let's get into the difference between murder and the aggravated manslaughter. It's the intent. Was this a premeditated, intentional murder? Obviously, the jury said no.
Absolutely. And there was no premeditation. There was no intent. I know that was the original charge, but there was no intent here. There's no way. And we had it on tape. He clearly was not trying to kill his kid. He was an idiot, and he got convicted accordingly.
Yeah, and the aggravated manslaughter carries 10 to 30 years. But I understand that the judge is now addressing the attorneys. Let's get back inside the courtroom. All right, court is over. You can still see the defendant there learning his fate. The sentencing has just been set by the judge for August 2nd of this year. I want to bring back in National Trial Attorney Michael Jaafar. Listen to, I was just saying, 10 to 30 years is the possible sentence for the aggravated manslaughter. Of course, then they'll be separate for the endangering. That might run consecutively or concurrently. But in this case, one of the things I wanted to talk to you about was, had he been convicted of murder, in this case with this particular child who was only 6 years old, he would have been sent to prison for life without parole because the child was under the age of 14. So for the defense team, this is a huge win.
I think it's a great win. On a Friday, they go out, they have every cause to celebrate. They did an excellent job for their, when you're a defense attorney, you go in, even sometimes when your client is convicted, it's a win if you get them sentenced in a certain reasonableness, right? They did an excellent job. They had no plea on the table, by the way, for this. I think if they had a plea on the table for something like this, they would have taken it, they would have pounded the table for their client and said, take this plea. That was not offered to them. They got it with the jury. I think they did a great job.
And one of the things they did, we know, is Dr. Bodden testified as an expert on behalf of the defense to say that the child died of natural causes, that he had fast-acting pneumonia. That's not the correct medical term, but, and also then he had a laceration in his heart. And so at the end of the day, it was a battle of the experts. I think that it means that they believed that the injuries to the child played a part in the death of Corey, and that those injuries were caused by the father.
Yeah, I mean, if the child slipped and fell in the kitchen and then died because the dad left water on the floor, I don't think anybody would have batted an eye and charged him, right? But because of the fact that he put him into such an extreme, they tell you on those treadmills, do not let a kid go in a sauna, in a whirlpool.
Yeah, they do.
And they tell you that for a reason, because not every kid can sustain that type of an injury. So, yeah, I think the battle of the experts weighed in his favor in this case, but still, yeah, he set up the crisis.
And you know, videos are our best evidence, Michael. And so when you see a video like that, it was disturbing on so many levels. And the defense tried to say in closing, the father was trying to put him back on there and put his feet on the sides and was just helping him get back on the machine. But when you watched, and clearly the jury agreed with what I thought, when you watched that video, it just broke your heart for that little boy, because he would fall and he'd put him back up there. And then when he had his mouth on the boy's head, we're watching the video now, right there, when the mouth is on the boy's head, the defense tried to really make light of that and say it really wasn't anything significant, substantial. You watch this and you think, if this is the way he's acting with his son in this one video, how must he have been acting the rest of the time when the mother testified about bruises and calling the child welfare agency? I think this video sealed his fate. I
think this video, it's jarring. I mean, I'm kind of disoriented looking at it, Judge Ashley, because of how painful it is. I've got, you know, 2 boys that age, so it's just disorienting. I don't believe that there's a world where parents do what we're seeing right here with this kid on the treadmill. And now we know that the kid was sickly, and you put him on the treadmill, and he was having, you know, basically blunt force trauma at your hands.
Yeah.
So I think it was a proper conviction.
And to hear from you, a male, like the defendant's a male, that you have 2 children that age, and you wouldn't have done that to your kid on the treadmill, speaks volumes. I think it weighed a lot for the jury. Still with me, National Trial Attorney Michael Jaafar. All right, Michael, we're listening to this together. Everything that glitters is not gold. Talking about Lori Vallow, really throwing her under the bus. She had 4 prior marriages. Is this enough to save his life?
Yeah, it kind of stunned me a little bit. I think this, in conjunction with other things, is enough for the jury to not recommend death. But it kind of disoriented me a little bit, because I know that Chad Daybell did not file a divorce against Lori, which I expected him to do. When he didn't do that, I thought, hey, they're not going to throw her under the bus. This is throwing her under the bus.
Completely. Yeah. I agree.
It's crazy. So I was a little bit disoriented. But yeah, it is definitely going to be mitigating factor. He's got 5 kids. They're alive. You know, he was married to Tammy for 29 years. He does have no prior criminal record. I don't think all the aggravating factors are there. I don't see a heinousness. Look, the fact that J.J. Vallow had autism, to me, that's atrocious. That's an aggravating factor. But I feel like that, in conjunction with what John Pryor said, I'm tipped over the edge to say there's going to be no death penalty. And I think it was you, it might have been Michael Ayala I was speaking to about this case, and there's been no evidence that Chad laid his hands on the 2 children. There's been no evidence presented. Maybe the jury will remember that and think of that. And I agree with you. I think throwing Lori under the bus is a good idea, because even if the jury feels she was manipulative, but it wasn't enough to save him from the convictions, it might be enough to save him from the death penalty. So we're going to wait together and watch. We have to take a break. Coming up next, impact statements by Tammy Daybell's father first, Ron Douglas. He'll be speaking, and we'll get you inside that courtroom.
Still with us in studio, National Trial Attorney Michael Jaafar is here. Michael, when you're hearing him talk about the fact that Chad Daybell's kids don't have communication with their mother's side of the family, that hurts to hear.
Yeah, no, it completely hurts. So many times I hear from grandparents who are prohibited from seeing their kids, their grandchildren from their kids, because the parents have the ultimate say-so. But in this case, the children themselves have broken off communication. It's always painful, because it's your kids' kids, right? You love your kids as kids. I would say just as much, if not more. To not be able to see them after you lost your kid, it's heart-wrenching. It's difficult. There's no solution to it.
And speaking of those kids, we thought that they might be taking the stand on behalf of their dad. We learned today the shocking moment that he's not going to be putting on a mitigation defense. We dug into our Court TV archives to see some other defendants who seem to not want to fight the death penalty. Henry Segura was one of them. He was convicted of killing his girlfriend and killing 3 children. And there he is back in 2019 during that trial. He didn't want his lawyers to present any mitigation evidence. He even waived his right for an opening and closing. So that's different than we're seeing here. John Pryor is doing an opening and closing. The jury in that case gave him life. Scott Nelson is another one in Florida as well. He took the stand and told the jury, I deserve to be executed. His attorneys, though, put on mitigation evidence, said he's mentally ill, and he just wants his own cell on death row. It's not fair. You should give him life. The jury, again, gave him life. Why do you think Chad Daybell made this move?
I think Chad Daybell's different. I have a theory. I think Chad Daybell is doing it for completely different reasons. He truly believes he's the prophet. And so if you're the prophet, like all other prophets before you, not a single prophet begged for their life or asked another human being to spare them. My theory is that he just put his hands in his Lord and Savior and said, it's out of your hands. Whatever God's will is, God's will is. I don't want anybody to say. I think if he would have come out there and did anything to be seen, sit back now and write books and tell people, hey, come to me, you're my flock now, right? I think he's looking down the road. He's a convicted felon of killing 3 people. I think he's looking down the road and saying, I got to maintain this whole prophet thing because I'm not going to appeal this thing. I'm not going to get out of jail no matter what I do. And if I die, I die, but I don't think I will. I think I'm going to live a long, healthy life, be skinny in prison, and be a prophet.
We will see what the jury does, if they are in line with what we've seen other juries do in this situation. Don't go anywhere. We have to squeeze in a break, but we do have someone who is connected to Tylee Ryan, who's going to be giving an impact statement. We do have to squeeze in a break. Let's first bring in National Trial Attorney Michael Jaafar. Michael, reading these notes from our team that's there inside the courtroom, they said there's been some tension between John Pryor and Chad Daybell. That Chad Daybell at one point looked a bit flushed when the testimony was coming out, but that things seem to have resolved now. But that at the beginning, when that we're not going to put on a mitigation case information was coming out, there seemed to be some tension. And what are your thoughts, rather, on seeing him sitting there listening to all of this?
I always look at it from the standpoint of a defense attorney, right? So as a defense attorney, John Pryor sitting there, he feels trapped. He feels like he wants to get up there and fight. Your whole being as a defense attorney is you want to stand up and you want to fight, right? When your client clips your ears and says, you're not going to fight, you're not allowed to fight, you want to sit here and take it like, you know, I got my pride on the line, I've got my career, this is what I'm built to do, why'd you bring me in here? But he can't leave, he can't quit and leave the courtroom because that would be even worse. So I feel like there should be tension. I would be fuming. If I was Chad Daybell's attorney, I'd be sitting next to him, I would be rolling my eyes. I might even privately grab him by the lapels and say, we can't do this, we gotta fight a little bit. But Chad Daybell thinks he's a prophet. So you're sitting next to the prophet, you got to do what I do, what I want you to do.
That prophet is no doubt watching this jury, and our notes from inside of that courtroom are saying that there are 3 women who are on this jury who are in tears over the testimony that's coming out. But that's not necessarily an indicator as to whether they're going to find for life or death.
Yeah, I agree. I think what would weigh on their minds is the fact that J.J. Vallow was autistic, right? And they've seen videos in this case where J.J. Vallow, I mean, he's just a sweet kid, right? Any kid that age would be sweet, but somebody who's autistic would be even more. So I think that's got to be weighing on their minds because now it's just setting in that, hey, these kids, they're not going to come back, and so it's understandable that they would be highly emotional.
7 people on death row in Idaho. They've executed 3 people since 1977.
Michael, I'll begin with you. We're on our 27th witness. In this case, it's day 2. Yeah. They're coming in fast and furious. Each one has a little to add to the case. Not sure the ball was moved too much today. Certainly, David Swift liked to talk a lot. Some of that might come back to haunt him. But how's it going for you today?
I think yesterday I started getting convinced by the end of the day after I heard my 3rd witness yesterday use the word stalking without seeing an objection by the defense. The picture's becoming more clear. Obviously, the lack of forensic evidence, everybody knows. It's like the big, the screw in the tire, no pun intended, of the case. And if he doesn't get convicted, it would only be because of that. But I think so far, the prosecution is doing the best they can. They're making chicken soup with the chicken that they have. So we'll see what happens tomorrow, and we'll see when they rest their case.
Yeah, I think they are getting to the. I think this is what they have. This is what the case is. Because remember, they didn't bring this case initially. You know, they basically had a lot of this evidence. They sat on it for years. A new DA took over the case, looked at it as a cold case during COVID, and decided to bring charges. Michael, what do you make of the testimony?
I've seen people get convicted on less and acquitted with more. I think this case is built primarily on gossip, but the fact that now I hate this defendant means the prosecution is doing the jabs that they need to do. I hate this guy now because here's his wife, 44-year-old woman, pulling herself up from her bootstraps. An intrepid girl got her license to be a physical personal trainer. She was doing landscaping on the side. She had to borrow money to file a divorce. You feel for her. So they're doing the best they can. They know they have no forensic evidence, so they have to do what they're doing now, which is making you hate the guy, painting him out to be a villain, and just kind of hope for the best.